Ready. 5 seconds. Start. Heard learned counsel for the applicant and learned AGA for the state. Full stop. This application has been filed challenging the order dated entertain an application move on behalf of the applicant claiming to be a juvenile and he is entitled for protection under the Juvenile Justice into bracket care and protection of children bracket close Act, 2000 in bracket hereinafter refer as to Act bracket close full stop. A copy of application has been annexed as annexure 5 to the affidavit, stating therein that the two sessions trial were amalgamated and capital ST number 425 of 2003 is the leading case. Full stop. The applicants Pankaj and Neeraj claim to be minor and in the circumstances, a separate trial was liable to be conducted. Full stop. It was stated in the application that the were students at the time of occurrence. Full stop. The date of birth of the applicant Pankaj, son of Shri Charan Singh Saroha, is 17 March 1986 according to high school certificate, and the applicant number 2, son of Shri Raj Singh, was born on 22/11/1987 as recorded in the school living certificate. Full stop. The application was moved on 6/5/2005 that common trial should not proceed, but the applicant was not entertained on the ground that since the Juvenile Justice Board has been constituted at merit, it is the jurisdiction of the board to decide and declare an accused as a juvenile. Full stop. This application has been moved challenging the said order. Full stop. It has been argued that Section 7 of the Act prescribed procedure to be followed by a magistrate not empowered under the Act. Full stop. Subclause 1 of Section 7 provides that when any magistrate not empowered to exercise the powers of a board constituted under the Act is of the opinion that a person brought before him under any of the provisions of the Act is a juvenile or the child, he shall without any delay record such opinion and forward the juvenile to the competent authority having jurisdiction over the proceedings. Full stop. Subclause 2 of Section 7 provides that the competent authority to which such proceedings are forwarded under subsection 1 shall hold the inquiry as if the juvenile or the child had originally been brought before it. Full stop. In the circumstances, it was the duty of the court to have ascertained and form an opinion whether the person, such a juvenile applicant in the instant case, was a juvenile in his opinion or not. Full stop. He could not have thrown away the applicant and refused to entertain it only because a juvenile justice board has now been constituted as merit. Full stop. It is also relevant to point out that Section 6 subsection 2 of the provides that the power conferred on the board by or under the Act may also be exercised by the High Court and the Court of Session, when proceedings comes before them in appeal, revision or otherwise. Full stop. In the present case, this application was moved before the learned session judge, Bhagpat, and therefore he was bound to make a preliminary inquiry and come to a conclusion, instead of regretting the applicant to approach the board. Full stop. It is also noteworthy that the Juvenile Justice Board constituted under the Act do not meet each and every day as a regular sitting of the court, and in the circumstances, the learned session judge Bhagpat should have least examined the matter, and if he was of an opinion that the applicant were juvenile, then an appropriate order should have been passed, which the court had failed to do so. Full stop. In the case of Bhola Bhagat and others versus State of Bihar 1997 into bracket 35 ACC, 835, the apex court had held that whenever a plea is raised by an accused that he was a child and the court entertains any doubt about the age, it has to hold an inquiry itself for determination of age or cause an inquiry to be held and seek a report. Stop.